good evening to respected dignitaries and everyone present. Welcome to yet another session organized by the Delhi High Court Legal Services Committee for legal enlightenment of its empaneled advocates. Today's event holds significant importance as we are privileged to have amongst us distinguished resource person and a retired judge of the Delhi High Court who many of us have surely encountered during our legal pursuits. Let's give a huge round of applause and welcome our guest and resource person for today, Ms. Justice Mukta, former judge, Honorable High Court of Delhi. I would request Mr. Arul Verma, Additional District and Sessions Judge and Secretary, Dhclsc, to kindly present a potted plant and a memento to ma'am as a token of gratitude. Thank you, ma'am. Thank you, sir. The chosen topic for today is of immense interest, bearing the potential to catalyze advancements in Indian criminal law. And who better than Mukta Gupta ma'am can shed light on this pivotal topic. So, to begin with, I would invite Mr. Arul Verma to kindly render his introductory remarks and express his gratitude for ma'am's presence here today.
Good evening, ladies and gentlemen. This is a momentous day in the annals of history of the Delhi High Court Legal Services Committee, for we have amidst us a legal legend, a luminary in the arena of law and justice, and a distinguished personality who really needs no introduction. Justice Mukta Gupta ma'am has left an indelible impression on an entire generation of lawyers and judges by her acts, by her words, and by her verdicts. We are all aware of the seminal cases which she has represented as a standing counsel for the government of NCT of Delhi. That is the Tandoor case, the Naina Sahni case, the Jessica Lal murder case, the Nitish Katara case. She has also, she's been lauded for her stellar prosecution for cases related to the 2000 terrorist attack on Red Fort and the 2001 attack on our Indian Parliament. So, these things you're aware and you know what ma'am has done. But today I'll endeavor to share some vignettes of her contributions and her achievements, which, very few, perhaps only known to a select few. So, for instance, this grand auditorium, this state-of-the-art building, in which we have our programs, owes its genesis to a number of meetings of the Building Maintenance and Construction Committee, the BMCC of the Honorable Delhi High Court, of which ma'am was an integral member. So I think we thank you for this, ma'am. We all know that ma'am has been a lawyer, she's been a prosecutor, and she's been a judge of the High Court. But did you know that in 2000, ma'am had topped the coveted Delhi Higher Judicial Service exam? And yet she continued to practice the law, and instead of joining as an additional district and sessions judge. I spoke of indelible impressions. So it wasn't mere rhetoric. I mean that because now when we trudge through those NCRT books with our children, our eyes will light up with joy when we see ma'am's name in the NCRT books, because she's mentioned therein as a role model public prosecutor. So yes, ladies and gentlemen, she has gone down in history as the only non-political lawyer in the country whose profile has been included in the 8th standard curriculum in NCRT textbooks. And as we all realize, one of the major tasks of a judge is to bridge the gap between law and society. And in that endeavor, the judge is a partner in lawmaking. It is the judge-made law which infuses life and infuses meaning to a statute, and it bridges the gap between law and life's changing reality without changing the statute itself. In this context, I would urge all of you to go through ma'am's seminal verdict, Akshay Chadda versus State, where she grasped the fact that a lot of children are hooked into drugs by using inhalants, that is Sulochan and whiteners, and she interpreted the term intoxicating liquor under section 77 of the JJ Act to include within its ambit such inhalants. And let me apprise all of you that the ramifications of such a seminal verdict has resulted in creating a safer environment for children across the city. And speaking of juvenile justice, ma'am has also been the chairperson of the Juvenile Justice Committee, wherein she has rescued 13 girls from the GB Road, the red light area, and rehabilitated them. And under her leadership, many children in conflict with law have got a new lease of life. They've been able to start life afresh and have even joined corporates such as Twibo and King Burger. So I think that is phenomenal. She's gone beyond the routine mandate of a judge, and I'm also cognizant of the fact that I've embraced prolixity, and today I'm shunning brevity. But and I have perhaps exceeded the normal time limits for an introduction. But I cannot refrain myself from rendering this special introduction, because we have amidst us a very, very special person. So ladies and gentlemen, please welcome ma'am with a resounding applause and a standing ovation, please.
Good evening, everyone. It's such a pleasure to come back to this High Court and be amongst all of you, a place where I've lived my life all through. And let me tell you, I've never dissociated and never will dissociate from this place, and would love to come again and again. And so when Mr. Arul Verma said, let's have one program on the 3 new laws, I wasted no time in accepting it and said, yes, of course, who will lose out on the opportunity to come to this place? These laws will now come into force on the 1st of July 2024, and we'll all have to gear up for this, especially those working on the criminal side, whether it's defense lawyers, prosecutor, judges. And one of the most challenging things which you'll have is some of the matters you'll have to do as per the IPC, some as per the BNS, because offences which take place after 1st July, from 1st July, will have to be punished as per BNS, though the procedure will be, of course, can be varied, but the fact is, as far as the offence is concerned, it is the one which is applicable on that day, and it can never be retrospective or prospective. It will start from the date when it is notified. Now, we all know that law is an embodiment of a social demand, and it evolves with society. Undoubtedly, there is a lot of change in the society, and with this change, we needed some changes in our law, and there are some very important provisions which have been added, but by and large, the 3 criminal laws are substantially the same old provisions, only the number of the provisions have changed. And the manner, the sequential number may have changed. So, the best part for you people will be that when you see that this is the same provision, you can follow the earlier precedents which were applicable, because if there is no change in the language, the earlier precedent will be applicable to it. Now, ultimately, the efficiency of any new law depends on 3 major factors. Firstly, how the legislature legislates it, then how the judiciary interprets it, and then how the executive implements it. Now, in judiciary interpreting, the lawyers play a very, very important role. Unless you bring complete facts to the notice of the court and bring the complete law to the notice of the court, at times one may land up passing a wrong judgment, which can have a far-fetching consequences, and I would request all of you to be very careful while dealing with the new laws, lest we all have to then have repeated judgments on that. Now, some of the new provisions which have been added in the Bharatiya Nagrik Suraksha Samhita, which we can all now conveniently call BNSS, is one which I would say may be very drastic, giving extensive powers to the police, which is section 43(3) of the BNSS, which provides for the power to the police officer to use handcuff while making arrest, keeping in view the nature and gravity of offence such as habitual offender, one who has escaped from custody, one who has committed organized crime, terrorist act, drug-related crime, possession of arms and ammunition, murder, rape, POXO, offence against the state, etc. Now this is, I think, to my mind, a very extensive power given to the police, and Supreme Court has already held that it's virtually in the rarest of rare case, and then you will seek the permission of the magistrate before doing it. With this provision, I think the police need not go to the magistrate, though the magistrate can seek the justification of putting handcuffs for the reason. Power to do an act is one thing and justification to do that act is another thing. So even if the police has power to use handcuffs, they will in any case have to justify their action. So I think the onus is now on the lawyers, and a very heavy onus, to ensure that the people are, especially with the presumption, the rule of law prescribing presumption of innocence in our country, till one is held guilty, that they are not handcuffed and paraded so that people's dignity is compromised. And of course, these matters will come up repeatedly before the courts. Courts will also take a view, but of course, with the assistance, able assistance from all of you. Now, there is another provision which has been brought in is section 105 of the BNSS, which provides for recording of search and seizure through audio, video, electric modes. The audio, video, electronic modes would be preferably a mobile phone, and the police officer is mandated to forward such recording to the district magistrate, SDM or judicial magistrate of the first class without any delay. Now, this was a requirement for a long time because undoubtedly video recording may help giving you what is the complete profile of the place, how it looked, what were some things there or not. But some challenges, of course, you people will have to face, especially during the trial and at the appellate stage, whether in the video the complete place has been captured or not. The police can selectively capture the video, and then you have to be very assured that there is no cutting, erasing of that video clippings. The entire place, scene of occurrence has been captured. Search and seizure was done properly, and there will be further challenges of the admissibility of that search and seizure, whether that video recording is proper or not. There are amendments to the Evidence Act also, the Dhclsc Adhiniyam, Bharatiya Dhclsc Adhiniyam, wherein section 63 of the Act provides for electronic admissibility of electronic evidence, which is to great extent same as 65B certification, plus it's provide that it is going to be an original document. It has to be treated, which documents have to be treated as original and which are to be treated electronic documents as a secondary. Now for original, if the original piece is before the court, then the 65B certificate may not be relevant, that's necessary otherwise also. But then how tempering has not been done, it has been properly taken, what was the time, what was the angle, these are all issues you people will have to cope up. I conducted an appeal, and I'll give you an example how small little things happen. In that, the police officers, it was a case of kidnapping for ransom, and 4 boys were arrested. Finally, they disclosed that they have dumped the body in some farm in distant place in UP. So they took them. When they reached, it was 11 o'clock in the morning. Now, when they started digging in that place, since the burying was done, say around 2 months, there was the mud was hard, so they couldn't dug it. So they called the professional people to dug it. So for that, they went to the nearby place, called the people. By the time it was evening, when they did digging at the same place, and body was recovered. Now the plea was, now see, when people are standing with the sun facing, the direction will change. So they said, no, they have changed. This is not the place they pointed out. In the evening, the place looks something different. So that this is a different place where now they have dug out the body. So it will not be admissible under section 27 of the Evidence Act. Now these are all small little issues which as lawyers you will have to work on. And it was a very ingenuine argument which we had to deal by looking into the evidence, because from the proceedings how it started, evidence of the witnesses. And then we thought that when they reached initially, it was actually sun was bright, and so the shadows were not there at that time straight on the head. By the evening it was a setting sun, so that is why this scene of occurrence looks like this. So all this, though video electronic modes are a preferable mode, now then it is in the mobile phone, then there is no tempering, all issues will have to be looked into. And then whether a police officer's mobile phone each time when he takes the search through video electronic mode, whether he deposits the phone, original phone, or what does he do? Does he make a copy out of it, or how it is exhibited in evidence will be yet another issue to be looked into. Section 86 of the BNSS provides now for identification and attachment of a property of proclaimed offender. We had a provision, section 83 CRPC, which now continues as section 85, being attachment of property of person absconding. However, this new provision, section 86, which has been added now, permits a court on the written request of a police officer not below the rank of a SP or Commissioner of Police to initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment and forfeiture of the property belonging to a proclaimed offender. So earlier this was that within India you could attach the property. 86 gives the power to attach the forfeiture, attachment and identification of the property of proclaimed offender even outside the country if there is an agreement between the states. Now, CRPC had to some extent chapter 7A, which had sections 105A to 105L with regard to attachment and forfeiture of the property derived from commission of offence in a contracting state, but that had nothing to do with the proclaimed offender's property. Now, section 107 of the BNSS provides for attachment, forfeiture and restoration of property derived or obtained directly or indirectly as a result of criminal activity or from the commission of offence. Such an application can be moved with approval of the Superintendent of Police or Commissioner of Police, and the attachment and forfeiture can take place either before or after taking evidence, but after issuing show cause notice and considering the reply rendered by the person. So this provision also allows attachment ex parte by way of interim order. Now, see, this is going to be a very draconian. Till now we've all been hearing PMLA, which deals with the proceeds of the crime. To some extent, and it has a scheduled offence, so only vis-a-vis the scheduled offence it can come. But now any offence in IPC, and as a result of which there is some property received, so that is liable to be attached, forfeited and restored under section 107 of the BNSS. Then again section 112 of BNSS, and this 107 again, in case of emergency the court can pass an ex parte ad interim order, but yes, order final which can be even before the trial, before the evidence is complete, can be on a show cause notice and after the reply is rendered by the person. And so at some stage maybe the person doesn't want to disclose all his cards before the defense, so that may be one of the issues which will come into play over here. Now section 112 of the BNSS permits the investigating officer to file an application before the criminal court if it is of the opinion that in the course of any investigation into an offence, evidence may be available in a country or a place outside India, requesting the criminal court to issue a letter to request to a court or authority outside India to examine any person acquainted with the facts of the case or to produce any document in its possession. Now this is made, earlier we had the letter regulatories which is not commonly used, but I think this section will easily help the criminal courts to get the investigation conducted outside the country for any evidence available, but how much it fructifies depends on the state into which a request is made and how they reciprocate it. Now section 113 of the BNSS permits letter of request from a country or place outside India to a court or an authority for investigation in India. So this is 113 is a reciprocal provision to section 112. So the contracting states outside India also can seek the help of a court or authority in India for the evidence. Section 172 of BNSS mandates all persons to be bound to conform to the lawful direction of the police officer given to him in fulfillment of his duty. Under this chapter, there was earlier provision, this is almost akin to 107, 110, but there are slight changes in this also. Now, one very important provision which has been added is section 173 BNSS. We've all known 173 as a charge sheet provision, but 173 is now going to be a zero FIR provision. Earlier there was no concept of a zero FIR, but now this zero FIR is going to be not a zero FIR but a complete FIR. Now 173, this 173.3 introduces the concept of a preliminary inquiry. In a case relating to offences punishable for 3 years or more but less than 7 years. So even if Lalita Kumari, the Constitution Bench in Lalita Kumari held that there cannot be any preliminary inquiry, this provision permits a preliminary inquiry for offences punishable for 3 years or more but less than 7 years, but this has to be with the prior permission of the DSP/ACP, and once the permission is received, the police officer can conduct preliminary inquiry and thereafter proceed to investigate if prima facie case is made out. Now, some element of truth is also there. Now, what is most important in this provision is not only the preliminary inquiry, it permits an investigation to be carried out dehoes the place of commission of offence. So, though it may be to some extent victim friendly, that you can go to some other place, get an investigation done over there, get an FIR registered, but this is going to cause a lot of problem, because an offence is committed in one state, person goes to another state, and the DSP gives a permission. On that permission, the police officer conducts a preliminary inquiry. He can start investigation. not only start investigation, he has the power to arrest, he can proceed further. Now, most of you must have done criminal law practice. Section 188 provided for the place of trial. But there was no, 154 never provided that only you will register FIR in your jurisdiction. So there was a concept of zero FIR, they would register FIR but send it to that jurisdiction where actually the offence was committed or it fell one of the categories of 188 CRPC. This provision actually goes beyond registering FIR. This permits investigation, arrest, custody, everything. But correspondingly, interestingly, there is no modification for the trial. For the trial, it will be the court of competent jurisdiction only. So the investigation will be carried out in another state, and whether they transfer the charge sheet, what they do, is all we'll have to now analyze and see how it works out. Because they don't say that if it's an investigation carried out outside of that jurisdiction, the trial will also be there. The provisions of trial still are the same, and in fact they provide that it will be the place where offence is committed. If I'm not mistaken, it is from 193 onwards, which these provisions are. I'll just come back to that. And then for serious offences, yes. Then section 183 provides that the judicial magistrate in whose district the offence has been registered, whether having jurisdiction in the case or not, is made competent to record the confession or statement in the course of investigation. Section 183 further amplifies this situation which is contemplated under 173. So the judicial magistrate in whose jurisdiction the offence gets registered, whether he may have jurisdiction to try or not, but he will have the jurisdiction to record the confession or statement in the course of investigation. Now for serious and heinous offences, it has been introduced in section 183 that in cases relating to offences punishable with imprisonment for 10 years or more, or imprisonment for life or with death, the judicial magistrate shall mandatorily record the statement of the witnesses brought before him by the police officer. This provision adds credibility to the criminal process. So in heinous offences, which is more than 10 years of imprisonment punishable, there the requirement is that the witness's statement should be recorded in the erstwhile, as we said, 164 CRPC, which will now be 183 BNSS. Now section 176(1) provides for more protection to the victim and ensuring transparency in investigation in relation to the offence of rape, requiring that the statement of the victim be recorded through audio-video means. Now, once it is recorded through audio-video means, then the identity, the issue of not disclosing the identity will also be a serious issue, and it will have to be ensured that this statement which is recorded in audio-video mode does not go out of the people who are authorized to have it. Now, to facilitate a speedy and accountable criminal proceeding, section 148(6) provides that the registered medical practitioner shall forward the report of examination of a victim of rape to the investigating officer within 7 days, who shall forward it to the magistrate. So a specific time frame has been provided to supply the medical reports and streamline the overall process of supply of documents. And otherwise we've been seeing that there are a number of cases where the medical report doesn't come for months together. Now there is an important change in section 187 BNSS, which is akin to section 167 of the CRPC. In the 167 CRPC, the police custody could be only for the initial 15 days. Now 187 provides that the total period of police custody will be 15 days, but it can be spread over from the first 60 days, 40 days in a case where the charge sheet has to be filed in 60 days, and 60 days in a case where the charge sheet has to be filed in 90 days. So they can have PC remand for 2 days, send him to judicial custody for 15 days, then again call him, then again send him to judicial custody, and then call him to police custody. Now this will have very serious repercussions. So if you see, initially whenever a statement of an accused was recorded, the court would say that no, send him to judicial custody, so that there is a sanctity, he is out of the fear. Now if the accused knows that after 15 days I can be again brought back to the police custody, or that this police custody to judicial custody can be a vacillating situation for the first 40 to 60 days, it may have those impacts during the course of investigation, especially on the accused. However, section 480 specifically provides to protect the rights of the accused, that the accused being required for police custody beyond the first 15 days will not be the sole ground for refusing grant of bail to the accused. Now generally, one of the arguments available to the defense counsel is police custody is over, so nothing is to be recovered. Now in this offence, please release him on bail. Now this from 15 days will get extended to 40 to 60 days, despite this specific provision of section 480. Now, to give further credibility to investigation, section 173(6) BNSS mandates forensic experts to visit the crime scene to collect forensic evidence for offences punishable for 7 years or more, and all the states have been directed to, as early as possible but not later than 5 years, make forensic evidence collection in such cases compulsory. Also, where forensic facility is not available for the time being, the state government may take the help of facilities from some other state. That's been provided. Now, section 185 and 105 BNSS have introduced certain checks on the powers of the police while conducting search. Firstly, the police officer is required to record the grounds of his belief for conducting search at a place in the case diary under section 185(1). Further, any search conducted by a police officer shall be recorded through audio, video, electronic means as per 185(2). Then section 185(5) makes the police officer accountable to send within 48 hours the copies of the record made in this regard to the nearest magistrate empowered to take cognizance of the offence. Now, these will, of course, as I earlier pointed out, will raise the issues of admissibility, veracity of these videographies, etc. But as we proceed, we'll see how to deal with all this. Now, to make the law more victim-centric and more victim-friendly, section 193 subsection 3 clause 2 mandates that the police officer must inform the progress of investigation to the informant or victim within 90 days of investigation. So technology has also been stated to be included as a mode of communication to the victim. So earlier, like, the victim was only entitled to an FIR, it says you will keep the victim informed about the progress of investigation. Now section 193 subsection 2 provides that in certain cases such as section 64, 66, 67, 68, 70, 71 of this BNS and section 4, 6, 8 and 10 of POCSO, the investigation must be completed in 2 months. Now see, the long-term effect is, even if it says the investigation must be completed in 2 months, it cannot be held to be mandatory for the reason the corresponding section 187(3) permits the court to take cognizance after 90 days. So it is not that if within 62 months the investigation is not complete, the accused will be entitled to be released on bail. The proviso to section 193(9) BNSS provides a timeline for conducting further investigation during trial. It has been provided that after filing of the charge sheet, if further investigation is required, it shall be completed within 90 days, and any extension of time period beyond 90 days shall only be with the permission of the court. So it still leaves a window open that you can conduct investigation further till any stage, but with the permission of the court. As I earlier pointed out, the provisions of place of trial have not changed, which were from section 188 CRPC are now from section 197 to 204 BNSS. Thus, the offence can be investigated in any jurisdiction, but the trial has to be by the competent court. Now imagine, first you move a bail before a court where the investigation is done. Then you move a bail before the court where the trial is done. These are issues which will arise now. Further, section 205 BNSS permits state government to transfer trial from one sessions division to another. Earlier, for any such transfer, one had to come to the High Court, but now the state government can always transfer from one sessions division to another. Now, section 336 of BNSS provides deposition by a successor of a public servant, expert, police officer or investigating officer, where a document report by such officer is to be proved, where during the course of evidence, such public servant, expert or officer has either been transferred, retired or died, or cannot be found or is incapable of giving deposition. So, but this says this officers will be called public servant, scientific officer only if the opposite side disputes the said report. Then only their substitutes will be called. Section 356 of BNSS provides for inquiry, trial or judgment in absentia. This is yet going to be one which will cause problem. Earlier, we all know in section 299 CRPC, it provided for separation of trial once the accused was declared that he is a proclaimed offender. His trial was separated and the trial for the other accused proceeded. But now section 356 provides that notwithstanding anything contained in this Sanhita and any other law for the time being, when a person is declared proclaimed offender and has absconded to evade the trial, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person, and the court, after recording reasons in writing in the interest of justice, proceed with the trial in the like manner and with like effect as if he was present and pronounce the judgment. So today the judgment can also be pronounced. Of course, I know the courts will now ensure that there is an amicus curiae to represent him, but that would be a meaningless exercise because unless the amicus curiae takes instructions from him, what defense can he bring in? Now, in sessions cases, timelines have been prescribed for delivering the judgments. Section 258 provides for a period of 30 days from the date of conclusion of arguments for giving the judgment. Such period may be extended to 45 days with reasons recorded in writing. Further, section 392(1) provides that judgment in every trial in any criminal court shall be pronounced no later than 45 days after the termination of trial. And within 7 days, the copy of the judgment has to be uploaded. Now, as far as plea bargaining is concerned, there are certain relaxations. Section 293 adopts a lenient and rehabilitative approach in plea bargaining cases. In instances involving first-time offenders where minimum punishment is prescribed, the court may impose a sentence equal to 1/4 of the minimum punishment, marking a departure from the existing norm. Further, in cases where the punishment is extendable and no minimum punishment is prescribed, a first-time offender may receive a sentence equivalent to 1/6 of the prescribed punishment, decreasing the quantum of punishment from the previous 1/4 standard. Now, to include the participation of the victim, the withdrawal of the prosecution, which was earlier in section 320 CRPC, which is now section 360 BNSS, provides that the withdrawal of before withdrawal of prosecution, the victim must be afforded an opportunity to be heard before the court. This provision obviously acknowledges and incorporates the concerns of victim in the criminal justice process. Now, section 392 mandates the preparation and notification of a witness protection scheme by every state government. So, the BNSS does not lay down any witness protection scheme, but mandates that the states will prepare a witness protection scheme. Now, how and in what manner those schemes are laid down will have to be seen. But as far as Delhi is concerned, we have a witness protection scheme in place pursuant to the decision of this division bench of this court, Neelam Katara's case, where an authority is appointed and the member secretary, Dhclsc, is the competent authority. On an application can be moved to that member secretary, who on an inquiry can direct granting the security. Now, section 479 relaxes and liberalizes the provision of bail to under trial prisoners, and for first time offenders would now be eligible for release on bond by the court if they have undergone detention for a period extending up to 1/3 of the maximum period of imprisonment specified for that offence. The provision also cast a duty on the jail superintendent to make an application for bail to the court where an under trial completes 1/2 or 1/3 of the sentence, more than 1/3 of the sentence. However, this provision will not be applicable to cases where the sentence is life imprisonment or death. Now, section 472 BNSS provides for that the mercy petitions can be filed by the legal heirs or relatives to the president or the governor, and the decision thereof shall be made within 60 days of the intimation of the dismissal of the appeal or review or SLP by the Honorable Supreme Court. Now, petition, it further lays that no appeal shall lie in any court against the order of the President or the Governor under Article 72 and 161 of the Constitution. Then there is a very important departure now. Section 218 of the BNSS, which is akin to section 197 CRPC, was sanctioned, This section provides that if the sanction is not given within 120 days, it will be deemed as if the sanction has been given. So, the best course will for the sanctioning authorities sit over the file, do nothing, and it will be deemed that the sanction is given, and of course you will have there will be no challenge of non-application of mind, incompetent authority, which were the usual grounds available. So 120 days it will be deemed to be granted, sanction has been granted. Now there is some more uniformities with slight modifications of previous CRPC. Now throughout the country there will be no metropolitan magistrates. It will be all judicial magistrates. Then the third class metropolitan magistrate and judicial magistrates and assistant session judge, these posts have been abolished. So there will be four categories of judges: judicial magistrate second class, judicial magistrate first class, which will include chief judicial magistrate and additional chief judicial magistrate, session judge including additional session judge, and executive magistrate. So they have brought in consequent changes in the BNSS on this ground. So the power of imposing fine by the magistrate of the first class has been increased from 10,000 to 50, and for the magistrate of the second class from 5,000 to 10,000. And community service has been now added as a form of sentence. Community service has been explained as court order work that benefits a community which is not entitled to any remuneration. This is as per explanation to section 23. Now section 25 of BNSS provides that considering the gravity of several offences, the court can direct punishments to run concurrently or consecutively. Firstly, it was never that it is considering the gravity, it said it is the discretion of the court. But now gravity of the several offences clause has been added into it. Section 35(7) provides that no arrest shall be made in case of an offence punishable for less than 3 years if the person is infirm or above the age of 60 years without prior permission of the officer not below the rank of DSP. Further, an aged or infirm person, if he is a witness and or he is above the age of 60 years, or a person with acute illness under section 179(1) of BNS, will be required to attend at no other place except where they reside. Now section 63 specifically includes technology compatibility for issuance of service of summons, and it says in electronic form authenticated by image of the seal of the court or digital signature. Now another change is section 70 allows service of summons through electronic means, and now summons can be effected under section 66 of BNSS on any adult member of the family, making the provision gender neutral. Earlier it said only on the adult male member, so the word male has been removed from there. Section 82 BNSS cast a duty on the police officer making arrest to forthwith give information regarding such arrest and the place where person arrested is being held to the designated police officer or to such police officer of another district where the other person normally resides. Now the scope of the offences under which a person can be declared a proclaimed offender has been expanded, and under section 84(4) of BNSS, all offences which are punishable with imprisonment of 10 years or more or with life imprisonment or with death have been included. Now section 145 BNSS, which is equivalent to section 125 of the CRPC, the parents can now seek maintenance and they can initiate the proceedings at the place of their residence. Now, these are some important changes which were brought in the CRPC, which now will be BNSS. Now in IPC, if you see, the main structure is almost same. There is a reorganization of the sections. Now abatement in IPC from section 107 to 117 has now been incorporated from section 45 to 57, except that section 48 has also been introduced, which provides that if the abatement of offence outside India for an offence in India would also amount to an offence if committed in India. So if the abatement is outside and the offence takes place in India, that would amount to an offence in India. This has been specifically stated in section 48. Now this may have serious implications where in a case of conspiracy or whether multiple accused, somebody is outside, so that he abetted, so he will also be liable. Now, as far as offences of criminal misappropriation, breach of trust, cheating are concerned, there is no change. In fact, section 314 of BNSS and section 315 of BNS are paramateria, same as section 403 and 404, which deal with misappropriation of properties. As regards offence of criminal breach of trust is concerned, section 405 to 409 have been verbatim added in section 316 BNS. So they are brought under one section under 316, making it subsections 1, 2, 3, 4, 5. Now section 317 BNSS incorporates section 1, 412, 413 and 450. Now cheating, which was defined under section 415 IPC, has been verbatim noted in section 318 and section subclause 2 and section 418, making it subsections in these provisions. Now forgery is verbatim the same, incorporated from sections 335 to 343. Fabrication of accounts, which was earlier section 477A IPC, is verbatim section 344 BNSS. So basically for IPC offences, only the change in numbers will be an issue, but not what is the import of the section, what is the implication of the section. But the major change which has come in IPC is introduction of three major provisions, which is organized crime, petty organized crime and terrorist activity, sections 111, 112 and 113. So an organized crime for which there were provisions, there was enactments like Makoka, which extended to Delhi, AP Koka, G Koka, etc. in number of states, though not in all states. Now with it coming into BNSS, it will be applicable all over India. And then two categories have been defined. Organized crime, economic offence has been included into it. Breach of trust comes under section 111 BNS, whereas cheating comes under section 112, which is a petty organized crime. So the definition of organized crime in these statutes and BNS is same, except that it has been elaboratedly by specifically including unlawful activities such as kidnapping, robbery, extortion, land grabbing, economic offences, etc. Further, another category of petty organized crime, including theft, cheating, have been added. Now see the dichotomy. The economic offence under the explanation to section 111 includes criminal breach of trust, but cheating is in a petty organized crime, whereas PMLA cheating is a scheduled offence and criminal breach of trust is not a scheduled offence. So you either use this provision, and now it gives discretion to the police officer to use the special provision. It is not that those provisions have been repealed. Though this act was to consolidate and amend, bring all provisions in one place, but we will have two provisions giving leeway to the police to use whichever they want. Now, these are the three major changes in the IPC, and as far as the Evidence Act is, only section 63 just elaborates the admissibility of electronic evidence, for which by and large it incorporates what is the settled provisions of law by the Supreme Court. But as we had earlier stated, that once we introduce electronic evidence in reception of or collection of investigating material, to what extent, what are the safeguards to be used, whether a mere certificate akin to 65B will be sufficient to ensure the veracity, I don't think has been built into. So this is where we'll have to work harder and find out in each case. I think this is slight sum up of the three new criminal provisions which will now come into force on 1st July. So all of you will have to gear up with this new challenge, and I'm sure all of you must have already started doing your work, but yes, the challenge will be half the matters you will be doing under the new enactments and half under the old, especially the penal code enactments. And then as far as the procedure, evidence is almost same. Procedure, of course, for the new will have to change, but yes, procedure is always, the courts can take a view and have taken a view number of times, that if the subsequent procedure is beneficial, even for the pending trials, the same would apply. To that extent, that ambiguity of course is there, which we'll have to see during the course as we progress. Thank you very much. Thank you very much for your patience.
Thank you, ma'am, for your profound insights. I, on behalf of Delhi High Court Legal Services Committee and everyone present here, extend deepest gratitude for your presence here today. Your words will resonate with us as we continue to navigate the complexities of law and justice. Thank you everyone for your time and presence here. I would now request everyone to kindly proceed towards the lounge area for high tea. Thank you so much.